Did you get an RFE from USCIS? What should you do? What to do if you receive an RFE, request for evidence from USCIS? During the immigration process, some correspondence from USCIS can directly affect the outcome of your case. One of the most important notices is an RFE, which stands for Request for Evidence. Today, I'm going to explain what an RFE is, why it happens, what you should do when you receive one, which case types tend to see RFEs more often, and most importantly, how to manage the process without panicking. What is an RFE? An RFE is an official request USCIS sends when they find something missing, insufficient, or unclear in your application. Here's the key point. An RFE doesn't mean you have been denied. Instead, USCIS is essentially saying, before we make a decision on your case, we need more evidence on these specific points. In the RFE notice, USCIS will list exactly which documents or explanations they want, item by item. So why do RFEs happen? An RFE doesn't only happen because something is missing. USCIS may issue an RFE for several common reasons. For example, requests for updated or additional documents. You may have included the document, but USCIS wants a more recent version, a clearer document, or a different format. USCIS may have misunderstood or needs clarification. If something isn't explained clearly enough, the officer may request more evidence. For example, about the nature of the job, degree equivalency, or the legitimacy of a relationship. RFE is a part of the standard review process. In some cases, USCIS uses an RFE to clarify the case before making a final decision. So don't forget, receiving an RFE does not mean your case is bad. Most of the time, it's an opportunity to strengthen your application. But let me be very clear. If you respond correctly and completely, your case can move forward. If your response is incorrect, incomplete, or disorganized, your case may be denied. That's why, especially for important or complex cases, working with an attorney is extremely important when you receive an RFE. What are most common reasons USCIS issues RFEs for? Missing documents such as passport copy, birth certificate, or financial evidence. Insufficient evidence. For example, in a marriage-based case, USCIS may want more proof that the relationship is genuine. Inconsistent information. If the information in the forms conflicts with supporting documents, you may get an RFE. Technical form issues. For example, wrong dates, missing signatures, using an outdated version of a form, and similar errors may cause an RFE. However, it is important to note a few things about RFEs. Receiving an RFE does not necessarily mean that the application was missing explanations or documents. It is possible that the USCIS officer did not review the file carefully. Sometimes you need to send the same documents with an explanation. It is important to do this as if you're explaining the case to a 10-year-old child. Plain English and detailed information are important in RFEs. Also, the RFE language is not always easy to understand. USCIS uses templates to create RFE notices, and these templates usually cover all possibilities. Therefore, it is important to understand what USCIS is really asking for. This requires experience in immigration law. If you're doing this for the first time, it is quite possible that you will misunderstand what is being requested by USCIS. Also, just because USCIS sends an RFE and requests specific information or a document does not necessarily mean that the case will be denied if you do not send that information or document. You may explain why that specific documentation does not exist or why you believe USCIS may have misunderstood the filing. RFEs are also a way to correct misunderstandings by USCIS officers. So what do you do when you first receive an RFE? First of all, read the notice carefully. What exactly did USCIS say is missing or unclear? Highlight it and take notes. You must check the deadline. The RFE notice will include a response deadline. USCIS gives 39 to 90 days to respond to an RFE. For example, in change of status applications filed using a Form I-539, the response time is 30 days. In most other cases, the response time is usually 90 days. Check the date on the RFE notice carefully. Your response must arrive at USCIS by that specific date. If your response is delivered to USCIS after the deadline, your case may be denied. Gather only what USCIS requested and maybe a little more. Sending too much irrelevant documentation can confuse the case just as much as sending too little. However, your response should address USCIS questions thoroughly. For that reason, it is important to be cautious and, when appropriate, include a little more than requested to create goodwill with USCIS. You need to organize your response clearly. Make it obvious which evidence answers which RFE item. Add short explanations when needed. Work with a trusted attorney. In many cases, the RFE response is the most critical step before a final decision. You may not have another chance. Professional guidance can significantly reduce the risk of mistakes and a denial. How to respond to an RFE? Send everything in one complete package. USCIS generally does not accept evidence sent in multiple separate shipments. Moreover, multiple shipments, multiple responses will probably not find the file before a USCIS officer decides on your case. Include a cover letter, and in the letter, match each piece of evidence to the specific RFE request. For example, in response to RFE item number 1, you are submitting the following documents. Also, confirm whether USCIS wants originals or copies. Copies are usually sufficient, but follow the notice exactly. Do not forget USCIS will not return originals. You need to keep proof of delivery of your RFE response. Use the shipping method with tracking and keep the receipt. You can use FedEx, UPS, or if you're using USPS, you can use certified mail or express mail with return receipt requested. Let's take a look at which applications tend to get more RFEs than others. Let's talk case by case. Some application types receive RFEs more frequently than others. H-1B cases. RFEs are very common in H-1B filings. H-1B RFEs often focus on, is the position truly a specialty occupation? Does the job description match the required degree or field? Is the wage level appropriate? Is the employer-employee relationship clearly established? If it's a change of status application, is the student maintaining his or her status while trying to switch to H-1B? In many situations, an RFE is simply part of the H-1B process, and many cases are approved when the response is strong and well prepared. I-140 applications. These are employment-based green card applications. RFEs are also common in I-140 cases, and they are often related to the employee's education and work experience, the job requirements and job description, the employer's financial ability to pay the offered wage, which we call ability to pay. Receiving an RFE does not mean your case is weak, but the quality of your response can be case deciding. How about marriage-based green card applications, I-130s and I-485s? In marriage-based cases, RFEs often focus on proving that the relationship is genuine. USCIS may want to see evidence of a shared address, proof of shared finances, evidence of day-to-day life together. And don't forget, even though you have sent these together with the initial application, you may get an RFE because USCIS now wants to see updated information or documentation. So these RFEs are common, and many cases move forward smoothly when answered correctly. 485 adjustment of status applications. 485 RFEs are often technical and typically involve the medical exam form, which is a Form I-693, proof of financial status of the petitioner or joint sponsor, including the affidavit of support, which is Form I-864, updated or missing documents. These RFEs are usually solvable and not a reason to panic. How about O1 EB-1 cases? Even very strong cases can receive RFEs in these case categories. In O1s and EB-1s, RFEs often focus on whether the evidence clearly meets extraordinary ability standard. An RFE does not automatically mean your case is weak. You just have to respond to it properly and explain your case one more time clearly. Change of status applications, especially changing status to F1, gets a lot of RFEs. These RFEs often focus on proof of non-immigrant intent, including ties to the applicant's home country, evidence of sufficient financial support, consistency between the applicant's education history and the proposed course of study, the location of the applicant's residence in relation to the school, timing issues related to the current status and enrollment dates, and also maintenance of status. How about E2 change of status applications? In E2 change of status cases, RFEs often address whether the investment is substantial, the source and lawful path of the investment funds, whether the business is real and operating, including payroll records and active operations, whether the applicant's role is truly direct and develop the enterprise and supervise employees, maintenance of status, whether the business is more than marginal. In E2 cases, USCIS often requests additional documentation to better understand the business and the investment structure. How about L1 cases? In L1 cases, RFEs commonly focus on the qualifying relationship between the US company and the foreign company, the applicant's prior managerial employment abroad, whether the US position qualifies as managerial, executive, or specialized knowledge, the operational status of the US company. The L1 RFEs are very common, especially for new offices where you request a 1-year L1, and often require detailed organizational and business documentation. It is important to note that L1 RFEs usually involve much more documentation than any other case type. So if you receive an RFE, don't panic. An RFE can feel negative, but most of the time USCIS is simply saying, give us more evidence and then we will make a decision. As long as your response is correct and complete, your case still has a strong chance to be approved. Sometimes the process moves quickly and sometimes it takes longer. So what happens after you respond to the RFE? Once USCIS receive your response package, they will reopen the file and continue reviewing it. Sometimes the process moves quickly and sometimes it takes longer. This varies case by case, and unfortunately, it is very difficult to give a specific timeline. If the case is under premium processing, USCIS will make a decision within the premium processing response period. You can also switch a case to a premium processing while responding to an RFE. If the response is sufficient, the case can be approved. If the response is not sufficient, USCIS may issue a notice of intent to deny or simply deny the case. So, risks and important reminders. Don't wait until the last minute. Gathering documents can take longer than you expect. Don't overload the case with irrelevant evidence. Too much unnecessary documentation can slow down the review, but make sure you include all relevant explanations and supporting documents. Make sure to read and analyze the RFE carefully and review your response and supporting documents to avoid mistakes. Your RFE response is often the most important final defense of your case, and it can determine the outcome. In summary, receiving an RFE is not the end of the world. In fact, it is often a chance to strengthen your case. Read the notice carefully, submit exactly what USCIS requests, never miss the deadline, and get professional help if needed. Did you receive an RFE from USCIS? Don't panic, you're not alone. I hope you liked this video. If you have any questions, please write them to me in the comments section and I will try to respond them as much as I can. Hope to see you in the next video. Take care.